Symposium on Sarah McLaughlin Mitchell and Andrew P. Oshek, Judicialization of the Sea, Bargaining in the Shadow of UNCLOS, Causal Inference, International Law and Maritime Dispute. Sarah Mitchell and Andrew Oshek examination on the impact of UN Convention on the Law of the Sea or UNCLOS and Article 287 Declaration on the peaceful resolution of maritime disputes significantly advances the literature on the relationship between international law or international court and maritime issues. To their credit, the authors employ a wide range of empirical tests in the article to provide readers with confidence in the empirical result. Nonetheless, there are some important limitations in their approach. Drawing on insight from the causal inference literature, I argue that Mitchell and Oshek's empirical analysis suffer from two biases that both raise concern about the causal relationship identified in the article and suggest some scope conditions in its empirical finding. I investigate the biases and propose suggestions for legal scholarship to produce more credible results. Causal inference and legal studies in this essay, I focus on the relationship between Article 287 Declaration and maritime dispute. The authors posit that Article 287 Declaration reduces the likelihood of new maritime dispute, decrease the use of military force, and increase the use of non-binding conflict management tools. The authors find the Article 287 Declaration decrease the use of force and increase peaceful settlement attempts, while they find the Article 287 Declaration are associated with the onset of more maritime dispute in contrast to their first hypothesis. I now turn to discussing the causal question in Mitchell and Oshek's article, Does X cause Y? While it is relatively straightforward to estimate regression models and compute the covariance between X and Y, it is much more difficult to identify the true causal effect on X on Y. To obtain the causal effect, we need to compare outcome in Y across different values of the treatment or key independent variable. However, estimating the causal effect of X on Y requires at a minimum that the treatment assignment mechanism, such as a state decision to make Article 287 declaration or X, is independent from or unrelated to the outcome of interest, such as a state decision to attempt peaceful settlement or Y. Violation of this assumption produces superior statistical result. Unfortunately, this assumption is unlikely to hold in Mitchell and Oshek's work or in most empirical legal research because government or individuals are rational actors that make decisions to advance their strategic interests. For example, it is likely that governments make Article 287 declaration with an eye toward managing their maritime dispute, which in turn violates the primary assumption in regression models because the decision to make Article 287 declaration is related to the decision to peacefully resolve or avoid maritime dispute. Indeed, the authors recognize this logic. Rational potential litigants seek the best outcome possible for themselves and consider various dispute settlement mechanisms to achieve that goal. In contrast to this, the alternative unrelated logic would be that government make Article 287 declaration randomly or without concern about managing maritime dispute, which seem unlikely. The consequence of this, however, is that the basic independence assumption is violated. Two sources of bias often lead to violation of the independence assumption, inhibiting the estimation of causal effect, selection effect, and heterogeneous treatment effect. The selection effect is whether there are systematic differences between governments that make Article 287 declaration and those that do not, while heterogeneous treatment effect are whether those in the treatment group state that make Article 287 declaration respond differently to the treatment compared to those in the control group, those that do not make Article 287 declaration. These two common sources of bias prevent empirical researchers from attaining the true causal effect in empirical work. The solution is for analysts to identify strategies that can reduce or remove the sources of bias so as to estimate the true causal effect. Mitchell and Oshik use several control variables and seemingly unrelated regression to minimize threat to inference. The authors are to be applauded for recognizing this issue, but problems remain. To that end, I put forward some suggestions below based on insight from the causal inference literature. First, with respect to selection effect, the concern is that there may be some differences between the treated group and the control group other than the treatment itself, and these differences are related to the outcome of interest. This is a problem because if these differences are not accounted for in the empirical models, then it is impossible to conclude that the treatment is causally related to the outcome, even if the model produces statistically significant result. Rather, it could be another omitted factor that is a common cause of both the treatment and the outcome of interest. It is therefore necessary to identify the factors that cause variation in the decision to make Article 287 declaration and to control for them if they are also related to the outcome of interest. Again, this is necessary to address in Mitchell and Oshik analysis because there are good reason to believe that governments strategically decide to make Article 287 declaration as the authors recognize. The basic pattern in the data also appear to indicate a selection effect. According to the author's data, while 164 states have ratified UNCLOS, only 47 have made Article 287 declaration recognizing the jurisdiction of the ITLOS, the ICG, or one of the two arbitration procedures for compulsory dispute settlement. That a small number of ratifying states have made Article 287 declaration suggests that those that do make them might be systematically different from those that do not make such declaration. Mitchell and Oshik include several variables in their analysis to counter concern related to selection bias. They further explore four possible sources of selection effect in greater detail. First, the declarers may have already resolved their maritime dispute. Second, state power. Third, regime type, or fourth, the salience of maritime dispute may shape a decision to declare. Mitchell and Oshek reject that these factors bias the analysis as they find few systematic differences between Article 287 declarers and non-declarers across these four variables. They conclude that it is not obvious what alternative common factor would explain both their willingness to make such declaration and their bargaining behavior across our myriad analysis. Although this is a useful start, the failure to find a relationship between the treatment assignment mechanism and the outcome of interest also raises a puzzle because it is again likely the actors strategically choose to make Article 287 declaration. Thank you.